And we have right here the search warrant, and the rules on search warrant can be found on Rule 126 of Rules of Court, the search and seizure. So search warrant is an order in writing issued in the name of the people of the Philippines, signed by a judge and directed to a peace officer commanding him to search for personal property, describe therein, and bring it before the court. So this is basically a document that is being issued by the judge, directing a peace officer to search for personal property described on the document. And when it comes to a search warrant, where can we file this one? Well, the application of search warrant shall be filed in any court within those or within whose territorial jurisdiction a crime was committed, and for compelling reasons stated in application, any court within the judicial region where the crime was committed if the place of the commission of the crime is known, or any court within the judicial region where the warrant shall be enforced. However, if a criminal action has already been filed, the application shall only be made in the court where the criminal action is pending. So when it comes to the application of search warrant, that can be found on Section 2 of Rule 126. And here's a question: what are the properties to be seized? So first is the subject of the offense. So this refers to property that is directly related to the commission of the offense under investigation. It could be an object, document, or item that plays a central role in the alleged criminal activity. The second property that needs to be seized: stolen or embezzled in other proceeds, fruits of the offense. So this category includes items that were obtained through criminal activities such as theft or embezzlement. It encompasses property that represents the gains or profits resulting from the commission of an offense. So let us say, for example, if someone steals money, the stolen cash or items bought with that money may be subject to seizure. And the third one is another property that can be seized, used or intended to be used as the means of the commission of the offense. So this pertains to property that is employed or intended to be used in the commission of the offense. So it could include tools, instruments, or objects utilized to carry out a criminal act. So an example of this would be a getaway vehicle, or tools used in a robbery case might fall into this category. And we have here another question: what are the requisites of search warrant? So we have right here, it must be based upon probable cause. So for a search warrant to be valid, there must be a probable cause, which is a reasonable belief that a crime has been committed. Second one is probable cause must be determined by the issuing judge personally. So the judge is the one who issues the search warrant, and it needs to personally determine as possible the probable cause by questioning the person requesting the warrant and their witnesses. And the judge must also take written statements from them. Third is the judge must have personally examined, in the form of searching questions and answers, the applicant and his witnesses, and have taken down the written deposition. So as what I've said, the judge must take written statements from them. And the search warrant must particularly describe or identify the property to be seized as far as the circumstances will ordinarily allow. So the search warrant must clearly describe the property to be seized and the place to be searched, providing specific details. And next, the warrant issued must particularly describe the place to be searched and the persons or things to be seized. So, as what I've said, it should have this specific details when it comes to search warrant. And it shall issue only for one specific purpose. So a search warrant can only be issued for a single purpose. And also, it must not be more than 10 days old at the time of the search. So it must not have been issued more than 10 days prior to the search made. And of course, these requirements ensure that searches are conducted legally with a clear reason and under the supervision of the judiciary. So here's another question. What is the time of making a search? So this is governed by, or we can see the answer for this in section 9 of rule 126, wherein here the warrant must direct that it be served in the daytime. Okay, so the warrant must direct that it be served in the daytime unless the affidavit asserts that the property is on the person or in the place ordered to be searched, in which case a direction may be inserted that it be served at any time of the day or night. So general rule for this, when making a search warrant, it's daytime unless it's specified in a document that you can only search things at any time of a day or night. So what is the validity of the search warrant? Here's another question, and we can answer this. We can find the answer in this in section 10 rule 126. So the warrant shall be valid for 10 days from the date of issuance. Thereafter, it shall be considered void. And we have here a question. What is a castle doctrine? It's basically a legal doctrine that designates a person's abode or any legally occupied place, such as a vehicle or workplace, as a place in which that person has protections and immunities permitting him or her to use force to defend against intrusion. So this doctrine actually allows individuals to use force, including deadly force if necessary, to defend themselves against unlawful intrusion or threat within their personal space. So it is a legal recognition of the right to self-defense within one's own residence or property, emphasizing the sanctity of an individual's personal space and the right to protect it from unauthorized and potentially harmful intrusions. And what is a scattershot warrant? A scattershot warrant is a search warrant issued for more than one offense. So in other words, instead of obtaining separate warrants for each alleged offense, law enforcement seeks a single warrant that allows them to search a specific location for evidence related to multiple suspected crimes. So this approach is employed when there is a reasonable belief that the evidence relevant to different offenses may be found at the same location. I think best example of this would be if there is credible information suggesting that a particular residence is associated with activities involving, let us say, illegal drugs, stolen property, and weapons. Rather than obtaining 3 separate warrants, authorities may seek a scattershot warrant covering all these potential offenses. And what is a general warrant? Basically, this is a search warrant which vaguely describes and does not particularize the personal properties to be seized. So basically, this lacks the necessary specificity required by legal standards, in contrast to a valid search warrant, which should be precisely detail the place to be arrested, to be searched, and the items to be seized. A general warrant uses vague or overly broad language that does not particularize the personal properties or items to be confiscated. So we have right here what is knock and announce principle. So knock and announce principle, it states that the police officers implementing the search warrant must announce their presence, identify themselves to the accused or to the person who has given the authority to allow the officer to search the premises, show the warrant to be implemented, and explain to them said warrant in a language or dialect known and understood by them. Hence, the officer has the right to break door or window to effect a search if after executing the knock and announce principle, he was refused admittance thereto. So according to this rule, for me to expound, When police officers are implementing a search warrant, they must follow a specific procedure. So, yeah, they are required to announce their presence, identify themselves to the person subject to the search, or someone authorized to allow the search. They also need to show the search warrant that authorizes their entry and explain the contents of the warrant in a language or dialect known and understood by the individuals involved. So what is the purpose of this rule? It's to provide transparency, reduce the likelihood of violent confrontations, and ensure that individuals are aware of the legal basis for the search being conducted on their premises. And here are the applications for search warrant. All applications for search warrant shall be approved for filing by the Chief of Office, and the application shall indicate the following data. So again, we have first office applying for the search warrant, the name of officer applicant, name of the subject if known, the address or place to be searched, the specific statement of things, articles to be seized, and the sketch of the place to be searched. Okay, so we have here another question. How many witnesses should be in the premises of a house to be searched when the latter or owner is absent during the execution of the warrant? So the answer to this would be 2 witnesses of sufficient age and discretion residing in the same locality. And these are the prohibited acts in the conduct of search by virtue of a search warrant. First, houses, rooms, or other premises shall not be searched except in the presence of a lawful occupant thereof or any member of his family, or in the absence of latter, in the presence of 2 witnesses of sufficient age and discretion residing in the same locality. Second one is that lawful personal properties, papers, and other valuables not specifically indicated or particularly described as search warrant shall not be taken. Next, this when it comes to the inventory and delivery of property seized. So, the police officer who confiscates property under the warrant shall issue a detailed receipt of property seized to the lawful occupant of the premises, or in the absence of such occupant, shall do so in the presence of at least 2 witnesses of sufficient age and discretion residing in the same locality. So this provision can be found actually in Section 11 of Rule 126, that when a police officer confiscates property under a search warrant, they must really provide that detailed receipt to the lawful occupant of the premises, or for those, if the lawful occupant is absent, then at least those 2 witnesses from the same locality. And second one, the receipt shall likewise include items seized under the plain view doctrine. So the receipt must also include items seized under the plain view doctrine, and the officer is required to live. The officer is required to leave a copy to the barangay official with jurisdiction over the search area, and this process actually ensures transparency and documentation of the seized items, with acknowledgement from the property owner or witnesses and notification to local authorities. That is the purpose why whenever there's a search warrant, there should be a detailed receipt that be given to the lawful occupant, or if the lawful occupant is absent, the receipt should be given to those 2 witnesses from the same locality. And we have right here, the 4th one, the police officer must forthwith deliver the property seized to the judge who issued the warrant, together with an inventory thereof, duly verified under oath. So this this is explained in Section 12 of Rule 126, the delivery of property and inventory thereof to court. So following the seizure of property under a search warrant, the police officer is obligated to promptly deliver the confiscated items to the judge who issued the search warrant. And along with the delivery, the officer must provide an inventory of the seized property, and this inventory must be duly verified under oath. This step ensures a transparent and accountable process, documenting the items taken during the search and providing an accurate record for judicial review. What is the general rule in effecting search and seizure? Well, just like arrest, the general rule in effecting a search and seizure is only by virtue of a validly issued search warrant. So what is the purpose of this? It's for the protection of the searcher, not to be charged of a crime of theft, robbery, and the like, and for any civil and administrative liabilities. And we have right here what are the exceptions to the general rule on search warrant. Well, the first one, warrantless search incidental to a lawful arrest. So it refers to the authority of law enforcement to conduct a warrantless search of a person and the immediate surroundings at the time of a lawful arrest. So the purpose is to ensure officer safety and prevent the destruction of evidence. And the second one, wherein search warrant is not needed, seizure of evidence in plain view. So this occurs when law enforcement, while in a lawful position, observes evidence of a crime that is immediately apparent. So the plain view doctrine allows officers to seize the visible evidence without a warrant. Another exception is search of a moving vehicle. So law enforcement can conduct a warrantless search of a moving vehicle if there is probable cause to believe it contains evidence of a crime. And vehicles have a reduced expectation of privacy due to their mobility. Another exception is consented warrantless search. So if an individual voluntarily consents to a search without a warrant, law enforcement can conduct it without violating the rights of a person. Next is custom search. So custom authorities have a legal right to search individuals and their belongings at border crossings and international entry points to enforce import and export regulations. Next is stop and frisk search. So this involves a brief, limited search of a person's outer clothing when there is a reasonable suspicion that a person may be armed and dangerous. So it is a safety measure for law enforcement. Next is exigent and emergency circumstances. So if law enforcement receives credible information from a reliable source, they may use that information to establish probable cause for search or arrest even without a warrant. And when we say search incident to a lawful arrest, it's a person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. And this is based, or we can know more about this on section 13 of rule 126, and this is one of the exceptions to the general rule on search warrant. And we have right here a motion to quash a search warrant or to suppress evidence. So where can we file this? It's stated on section 14 of rule 126. And we have right here a motion to quash a search warrant in order to suppress evidence obtained thereby may be filed in and acted upon only by the court where the action has been instituted. If no criminal action has been instituted, the motion may be filed in and resolved by the court that issued search warrant. However, if such court failed to resolve the motion and a criminal case is subsequently filed in another court, the motion shall be resolved by the latter court. So, a motion to quash a search warrant or suppress evidence can only be filed and addressed in the court where the related criminal action is pending. So, if there is no ongoing criminal case, the motion can be filed in the court that issued a search warrant. And if the court that issued the warrant doesn't resolve the motion and a criminal case is later filed in a different court, that court will handle and decide on the motion. This basically ensures that legal challenges related to search warrants are addressed in the appropriate court and within the context of the criminal proceedings. Yeah, and we have right here the Mapp versus Ohio case. So it is a landmark case in criminal procedure in which the U.S. Supreme Court decided that evidence obtained in violation of a rights which protect against unreasonable searches and seizure. So it is a case in which the court decided that evidence obtained illegally may not be used against someone in a court of law. And that basically ends our discussion about a search warrant. So if you have questions, just feel free to ask me.